For the record, this matter is before the court for the purpose of reviewing outstanding issues, primarily, as the court recalls, as plaintiff father's parenting time. This hearing is being conducted via Zoom. President is Attorney Russell Smith, representing the plaintiff, Alex Ortman. Good morning, Mr. Smith.
Good morning, Your Honor.
Mr. Ortman appears to be present with Mr. Smith. In addition, Attorney Christine Hills is present, as well as her client, the defendant mother, Cameron France. Good morning, Ms. Hills.
Morning, Your Honor.
Parties have conferred with Ms. Pratt in front of the court this morning, who has provided the court the following recommendation. Father's parenting time shall be every other weekend, Fridays at 5:30 p.m. until Sunday at 6 p.m. In addition, fathers shall have parenting time every other Wednesday, 5:30 p.m. until 7 a.m. Thursday morning. On the week, they does not have the weekend parenting time. Exchanges shall continue at the Bedford substation, and fathers will not be involved in the exchanges. Shall attend counseling every other week. The parties shall continue to communicate via app posts regarding the children. The parties shall return to this court to review parenting time November 19th at 8:30 a.m. via Zoom. That is the recommendation. Mr. Smith, is this recommendation agreeable with your client?
Judge, I don't think it is. We've talked about it. He wants some additional parenting time because of the preschool schedule. The recommendation would eliminate a Sunday overnight. Presently, he has Sunday overnights till a Monday. And what he proposed was 3 weekends for him as a resolution. That was rejected. We would ask that the court consider that, or as an alternative, that his Wednesday parenting time overnight be every week versus every other week. Fact of the matter is, since the last hearing, Judge, there have been no incidents of any type between the parties. He's satisfied the order that the court entered at the last hearing, and everything has gone swimmingly. He's just asking for some additional time. He loves his kids. He wants to spend more time with them. And I would urge the court to consider the 3 weekends as a solution.
Ms. Hills, the court does note that the parenting time has been shortened from the last order of the court, taking away the Sunday overnights.
Yes, Your Honor. The court had reserved the issue of school year parenting time so that we could address that today. It's my understanding this is a recommendation for the school year. We will be back November 19th for a review. The parties also need to choose a kindergarten, so there will be lots of opportunities for them to discuss summer parenting time moving forward. And we're very hopeful that Mr. Ortman can earn back the trust that he had again lost with my client, and that they can get to a more normalized parenting schedule with more parenting time for Mr. Ortman. We are not there yet. Mr. Smith mentioned that there had been no issues, and that is true as far as the communication goes since the last review hearing. However, just in the meeting with friend of the court this morning, Mr. Ortman made some very concerning statements that still lead one to believe that he does not accept his own role in where he's at right now with his parenting time. He continues to put the blame squarely on my client in large part for his issues that he's had with co-parenting and with just completely inappropriate communication. We are very glad that that has not happened, that he's been able to do what he needs to do since the last court hearing, but I think it's clear that there's a lot more work that needs to be done on his part in therapy. So hopefully he will continue that. This schedule provides some stability for Arlo. I realize it's preschool, it's Monday, Wednesday, Friday, but the child does need some stability during the school week. We have some limitations, which were the result of Mr. Ortman's actions in terms of the logistics of the exchanges, and those are taken into consideration in the Ms. LaPratt has made as well. Mr. Ortman has acknowledged that he is not available himself during the week to be with the child, and that the children would be primarily with his parents. My client did suggest that she would be willing to do Monday evening when he has not had the weekend for 5:30 to 7:30, so that he would have some contact during that more extended period where he otherwise would not see the children. That was not accepted by him. But I do believe that this schedule that's proposed for the school year does what's best for the children. And my client has even offered again an evening in addition to that. So we are asking that the court adopt the schedule that's been recommended for the school year.
Anything further, Mr. Smith?
I'm sorry, Your Honor, I didn't hear that.
Anything else on behalf of Mr. Ortman this morning?
Yes, Judge. My client has worked very, very hard to get to this point. He's doing everything that he's supposed to. He doesn't want to move his time backwards with the children. He wants to move it forward. He's recognized the fact that his relationship with Ms. Franz is over. I think she has remarried. He's fine with that. He just wants more time with his children, and he's worked very hard to get that, Judge. So, and, when the court read the recommendation from the friend of the court into the record, did it indicate that his counseling would be every other week going forward? I can't recall if I heard that or not, Judge.
A week, yes. He shall attend counseling every other week.
Very good. Very good. And Judge, I just ask you to give Mr. Ortman the benefit of the doubt. He's earned this. He really has. So I just ask you to award him the 3 weekends per month. Thank you.
Well, the court would note the parties did confer at length this morning with Mr. Pratt, and the court has confidence in Mr. Pratt being able to assist the court with these matters. And there is a review date. If in fact it's not acceptable, Mr. Brisk, we'll set an evidentiary hearing, because the court is quite honestly tired of these parties coming back every other month. We should have an evidentiary hearing, be done with parenting time unless there's a change in circumstances. We bring in the counselor. We have testimony about Mr. Ortman's mental health. So either the court's inclined to either adopt the recommendation with a review date, otherwise we'll just, with no review date, let's set an evidentiary and be done with it. I'm really, I just have this case coming back every other month for what? The last 12 months? There's got to be some finality to this. So, Mr. Smith, the court either adopts the recommendation with a review date or we'll set it for an evidentiary hearing.
I'm sorry, Judge, I didn't hear your last comment.
The court will set an evidentiary hearing if you oppose this recommendation.
You're asking me if I oppose it?
Was a hearing.
You want to go to a hearing?
I don't know what that entails.
1 second, Judge. I might mute myself. Judge, I've spoken with my client, and would you want the Monday? It's part of it.
Yeah, and Wednesday.
Yeah.
Yeah.
I've spoken with my client, Judge, and if previously Ms. Hills is offered the Monday 5:30 to 7:30, along with the every other Wednesday overnight, if that could be part of the package, my client is agreeable to the court entering that order.
That would be in lieu of the Wednesday overnights?
No, it would be in addition to the Wednesday overnight.
The Wednesday overnight is every other week as recommended when Mr. Ortman does not have the weekend. And then the Monday following Ms. France's weekend is what she had suggested, 5:30 to 7:30.
Correct.
Are you still agreeable with that?
Yes.
Okay.
So 1 week, it'd be Monday overnight, and the next week would be Wednesday overnights?
The Monday would just be 5:30 to 7:30, Judge. It would be
Oh, just the evening hours. Sure.
alternating Mondays, 5:30 to 7:30, and alternating Wednesday overnight.
Understood. And that's what you were referring to, Mr. Smith?
Yes, Judge.
All right. If that's agreeable, it sounds like it is. Mr. Pratt, you can add that to this recommendation. And yes, hopefully the parties can, between the two of each other, discuss the child care issues, whether they understand the oldest child is 4 years old. I don't know if it's a pre-K program or a daycare. Hopefully they can continue to discuss what's best for their children, including parenting time. And I think it's important that Mr. Ortman continue his counseling. I don't know, has you received any recent reports from the counselor, Ms. Hills?
We just got some this morning, Your Honor. I have not been able to dig deeply into them yet, but it does appear he's going and addressing his issues with the counselor.
Okay. All right. Well, thank you, Ms. Hills and Mr. Smith. We'll add to the recommendation, Mr. Pratt, alternate Wednesdays evenings.
Yes,
Now,
sir. I believe it's Monday, every other Monday after Mother's Weekend.
Right.
correct. All right, with that, the court will adopt the amended recommendation, Mr. Smith and Ms. Hills, and we'll put this back on our docket November 19th at 8:30, and hopefully the parties can make some progress on their own.
As long as the communication is appropriate, my client is more than willing to co-parent.
That would be wonderful, Judge. That's what I've been hoping for all along, is at some point, the parties will have the ability to exchange ideas regarding the children and have an actual dialogue. That would be a wonderful move forward, Your Honor.
Agreed.
Well, thank you, Mr. Smith, and the court's confident that with two very experienced family law practitioners, they can appropriately counsel their respective clients in that regard. All right, court will adopt the amended recommendation. We'll send one back on November 19th at 8:30.
Thank you, Your Honor.
You're
Thank you,
welcome.
Your Honor. Have a good day.
Thank you as well.
Later.
For the record, this matter is before the court this morning for the purpose of reviewing plaintiff father's parenting time. This hearing is being conducted via Zoom. President is Attorney Russell Smith, representing the plaintiff father Alex Ortman. Mr. Ortman is present with Mr. Smith. In addition, Attorney Christina Hills is present, representing defendant mother Cameron France, and Ms. France is present. Good morning, everyone.
Good morning, Judge.
The parties have conferred at length with Mr. Pratt this morning from the front of the court, who has provided the court with a fine recommendation that father's parenting time shall be specific as follows. With respect to holidays, parties shall follow the Monroe County Family Court holiday schedule. Otherwise, parenting time for fathers shall be as follows. Fathers shall have every other weekend, Fridays at 5:30 p.m. until Sunday at 6 p.m. In addition to every other Wednesday, 5:30 p.m. to 7 a.m. Fathers shall also have the Monday following Mother's Weekend from 5:30 p.m. until 7:30 p.m. The exchange of the children, I should say, shall occur at the Bedford substation of the Monroe County Sheriff's Office. The parties have agreed to mediate with Mr. Pratt on January 9th, 2024 at 8:30 a.m. And the issue of parenting time will be reviewed by this court February 5, 2025 at 8:30 a.m. That is a recommendation. Should the court now review parenting time on the subsequent mediation if necessary? Mr. Smith, Ms. Silser, do you want some breathing room between the mediation and the review?
Your Honor, what we discussed is if we do reach an agreement at mediation, we could vacate that review hearing. If we do not reach an agreement at mediation, I think that extra time following mediation could be helpful in the court making some decisions on what to do. Just a bit of extra time to see how things go with Mr. Ortman, a few more counseling sessions, or a couple more post-mediation, and just more opportunity for him to show good judgment or the lack thereof, as the case may be. But I think that extra time could be helpful.
All right, understood, and that makes sense, Ms. Sills, thank you. All right, Mr. Smith, does this recommendation agree with your client this morning?
Well, no, Judge, but quite frankly, I think we've made progress today. The parties were able to speak cordially to one another, and my client has some holiday parenting time coming up. Hopefully, everything will go smoothly between now and the time of mediation, and we can mediate it to conclusion on the date set and eliminate the other court date. That's our hope, Judge. So we wanted to move the meter today. We weren't able to get that done, but I think that both parties understand that it would behoove them to move the meter forward as things go along in this matter, Judge. So although we're not delighted about the recommendation, we are willing to accept it at this point with the idea that when we return, that things will move forward. So, yes.
All right, thank you, Mr. Smith. Ms. Sills, is this recommendation good with your client this morning?
It is, Your Honor, and my apologies to Ms. LaPratt. I should have raised this issue with her, but it is our understanding and expectation that Mr. Ortman would continue his every other week counseling in the interim.
Any objection, Mr. Smith?
No, Judge. I think that would be fine. Mr. Orban, do you have an objection to that?
No.
No, I think it's helpful, Your Honor.
All right, perhaps we'll can, Ms. LaPratt can do her magic and add a sentence to this recommendation for the court to adopt that the plaintiff father shall continue his counseling every other week. All right, with that addition, Mr. Smith or Ms. Hills, do you wish to voir dire your respective clients?
No, Your Honor.
No, Judge.
Well, after the court would note they're both involved in these discussions for the last hour. Very well. I would like to thank Mr. Pratt for her efforts this morning, as well as, of course, Attorney Smith and Hills for helping the parties reach this agreement. And the court will accordingly adopt the same with the addition that the plaintiff father shall continue counseling every other week. And that will conclude this hearing. Everyone can zoom out and have a good rest of the day.
Great. Thank you, Your Honor.
Thank you, Judge. Have a good day.
Thank you.
Thank you.
For the record, this matter is before the court on the plaintiff's motion to modify custody and or parenting time, as well as motion for order to show cause. This hearing is being conducted via Zoom. The present is the plaintiff father, Michael Rodriguez. In addition, attorney Stephen Rotenberg is present, representing defendant mother, Chelsea Rodriguez. Ms. Rodriguez is present. Good morning, everyone.
Good morning, Judge.
The parties have conferred at length with Ms. Brower from the front of the court this morning, who has provided the court with a fine recommendation that both parties must submit proof to the front of the court and the court that the SMA program and the high conflict solutions workshop have been completed within 7 days. The children shall attend Monroe Public Schools as previously ordered. Mother shall ensure the children attend Monroe Public Schools no later than tomorrow, September 5, 2024. Mother shall not leave the children unattended for any period of time during her parenting time. And finally, the show cause be dismissed. That is the recommendation. Mr. Rodriguez, do you understand the recommendation this morning?
Yes, sir.
Do you have any objection to the court adopting the recommendation?
No, the only thing I ask is for like the drop-off time is if she can come pick up her children when it's her time, because I've had my girlfriend go out there and she's failed to even show up to where it was for over an hour and then doesn't answer anyone's calls when it's time to pick up my children. And this is the main reason why, because she keeps keeping them against me, or just leaving them alone.
None of this was brought up. None of this was brought up in front of you.
I just filed a complaint, Stephen. Yes, it was brought up.
It was not brought up. Not in
All
this
right, well,
motion.
it's in the courts. So the complaint I just filed shows all
That's
that.
not up for today. That's not relevant for today.
I had the police number and everything if you guys need it.
That
If there's an
motion is
issue
not
with
in play today.
exchanges, we'll address that this morning.
That's fine. Yeah, that's what I'm trying to address.
Every
Okay.
week. So if there's an
Judge.
issue regarding exchanges and the time exchanges, we'll address that this morning.
Okay, Judge, couple
Thank you.
things.
Just a minute. Hold on, Mr. Rotenberg. Hold on. Ms. Brower, I'm trying to go through this thick file here. Is there any time where the parties meet right now for exchanges or where they meet? Perhaps they should meet at the law enforcement agency at a certain time.
Your Honor, I believe that they meet, it's in a recent order. Give me just a moment.
It's at the Canton Police Station at like
Okay,
6 o'clock.
Mr. Rodriguez, where do you propose that you meet for the exchanges? And I'll ask Mr. Rotenberg what he proposes.
Well, I'm just asking. She says she has off like an hour throughout the day here and there. So within her hour on my time, if it's possible, she could bring them to me during the day, and then my girlfriend watches them like it's been previously stated throughout the day until I get off of work. But
Judge
she just fails.
Hold on, Mr. Rotenberg. Stop. Mr.
You just
Rotenberg,
cut
don't
me off.
interrupt, please. I'm not going to interrupt you. Please do not interrupt. Otherwise, we're going to mute you. Please.
But yeah, so the last time I was supposed to pick up my children, it was probably about 2 weeks ago. My girlfriend went to pick them up at the Canton Police Station at around 6 o'clock, like we're supposed to. And Chelsea was just nowhere to be found. I texted, called, no answer. And probably till a couple of days ago, she finally answered me. I just haven't got a chance to even get a hold of my daughter. I don't know how my kids are doing. Yeah, I'm just confused on what's going on right now. But if she can meet me, if she can come this way for her children when it's time to pick up, I'll drop them off to her. That's fine when it's her time. But she can pick them up when it's her time. But I'm not. I feel like it's
You can't
just
communicate with Ms. Rodriguez about these simple things?
no. I can't. Unfortunately,
All right.
she won't answer me.
Your Honor, if I may,
Chelsea, sorry. I thought it was
Ms.
Chelsea.
Brower?
Referee Hamrich on August 14th recommended that the parties exercise all parenting time exchanges at the Flat Rock Police Department. That 21-day objection period ends this Friday. Neither party has filed an objection to that as of today.
All right, so I got to follow instruction.
I'm sorry, that was in August?
August 12th.
Recommended order?
August 14th. It's a recommendation at this point. I don't believe the court has it in its file.
Yes, not in the court's file. And that provided the parties meet at where the Flat Rock Police Department
The Flat Rock, yes.
at what time? Does it have specific times?
It does not.
Okay.
The parties would follow the previous court order for parenting time. I believe that gives father alternating weekends, Thursday at 6 to Monday to school or 9 a.m.
Okay.
Your Honor, if I may, the friend of the court also did an investigation and recommendation as far as parenting time. Neither party has motioned the court to adopt it, but the friend of the court's recommendation is to give mother alternating weekends, Friday at 6 to Sunday at 6, and that the children remain in Monroe Public Schools.
And Judge,
Yes, Mr. Rotenberg?
we would object to part of that recommendation, and I'll explain why.
Well, if that's
Ms.
not an
Rod-
objection, Mr. Rotenberg, I mean, in front of the court, the referee recommend order, that will take effect if there's not a written objection filed within 21 days.
Right, we're mixing, okay, I think what we're doing is we're mixing recommendations and orders a little bit, that there's multiple ones out here. This morning, Ms. Brower recommended, or is about to recommend, that the children remain in the Monroe Public Schools and the parenting time remain as follows. MCL 722.31 is the 100-mile rule, and that allows a parent to move within 100 miles without the court's permission. Ms. Rodriguez moved to Canton, which is about 40 minutes away by car from city center to city center from Monroe, to get a better job, which is in the best interest of the children. If she was to keep the children in Monroe Public Schools, that would force her to drive back and forth to Monroe 4 times or do 2 round trips a day during the school year. The kids would be in the car for at least an hour and a half a day more than they otherwise would be. They would not be able to participate in extracurriculars near where they live during the school week, and it would interfere with their ability to make friends with their new schoolmates in their new neighborhood. Now, Ms. Rodriguez probably should have asked for the court's permission to change that order to change where the children are enrolled. But there's no real difference that I know of between Canton Public Schools and Monroe Public Schools. And I think it would be in the best interest of everybody, wear and tear on the car, reducing the amount of travel time, reducing the amount of driving, because these children, I think, might go to different schools. I'm not sure if they all go to the same one or not. But as a practical matter, it puts a huge burden on them to drive in this car going back and forth. Okay, she could move up there without the court's permission. There's nothing wrong. There's nothing all that different that I'm aware of, as I said, between Canton Public Schools and Monroe Public Schools. So I'd say that we adopt the order, except that she can enroll them in the Canton Public Schools, because Mr. Rodriguez doesn't have them during the school week. It's on information and belief he doesn't drive.
I have a car right here.
Okay, well, maybe you do. Then I stand corrected. But as a practical matter, Ms. Rodriguez has a better paying job than she had before, earns more than she ever did, has benefits for the kids that she never had, and all this would do is basically force her to have to ask the court's permission to do what she's allowed to do by right, because that previous order might have been a little bit more restrictive than it otherwise should have been. It possibly should have said something along the lines, the public schools where the parties live, or something like that, because there's nothing, I'm unaware of any inherent property other than geography that would differentiate Monroe Public Schools from the Canton Public Schools. So that would be the extent of my objection to the recommendation. Now, as for all the other, as Mr. Rodriguez, let me finish. Now, as for the other thing, we have a bit of chaos here, in that I filed an appearance, and I did send it to Mr. Rodriguez, I believe, on the 12th. The appearance itself says that I request copies of everything filed in this case. I haven't received anything from Mr. Rodriguez. I haven't received his most recent objections. I got that from the friend of the court. I have not received anything. And I requested them, and he's wants to be his own attorney. I would like copies of those files. I haven't received them. The other thing too is it doesn't matter.
You could easily get that yourself.
Mr. Rodriguez, do not interrupt, please.
The other thing too that we have with this is he likes to file objection after objection after objection after objection, zillions of them, and then he mixes them all up and tries to fight them all at once. And it adds to the confusion of the case. So I don't really see anything other than a power play issue here, favoring Mr. Rodriguez having the children in the Monroe Public Schools if they're near if they're near Ms. Rodriguez. The other thing too with this is there's allegation that it's obviously these parties don't get along, but also Mr. Rodriguez has unclean hands. Both parties were ordered to participate in certain programs. I don't know if my client has or hasn't, but we sure as heck don't know if Mr. Rodriguez has or hasn't either, because again, there's been no proof.
I filed them.
As the attorney of record, and I am entitled to all filings. And if you want to play lawyer, we're all supposed to play by the court rules. Those are the rules of the road, so we don't have chaos. And this has become one hand clapping. So if Mr. Rodriguez, I would ask that Mr. Rodriguez give me copies of everything that's been filed in this case. Number one. Number two, we would ask that the court entertain allowing Ms. Rodriguez to have the children in Canton Public Schools, because there's no good reason to have them driving back and forth an hour and a half every day. Plus I don't quite know what time her shift starts or how this interplays with any latchkey programs or anything like that. I believe Ford starts pretty early in the morning, and I don't know, if memory serves me right, I think it might be a 7 o'clock shift. I don't know how the heck that this would even be feasible. We don't want to endanger her job.
So who's watching the kids?
The kids.
Mr. Rodriguez, can you mute? We're going to mute you, Mr. Rodriguez. You keep interrupting.
And as for who's watching the kids, Mr. Rodriguez, during the school year, if they're in school, it doesn't really matter. They're being watched by school staff. That's what we're talking about right now. If we have other issues with latchkey or daycare or other things like that, we can deal with that at another time. But right now we have a serious issue here as to adding hundreds of miles of road travel to these children's lives every week. And that's not in their best interest.
Thank you, Mr. Rosenberg.
Thank you.
Mr. Rosenberg, without question, Ms. Rodriguez, she can move to Canton. She can. But changing the schools on her own, that is not permissible without this court allowing that. She can't just unilaterally change the school district for the children. Mr. Rosenberg, have you received a copy of the recommendation of Catherine Scott dated August 26, 2024?
I'm unsure, Judge. I do not know. I don't have it in the file in front of me, but that does not necessarily mean I don't have it.
The referee Homrick on June 25th.
Yes, I have that. Yes.
Her recommendation is at the issue of school district, and she denied the request to modify parenting time. I'm sorry, she recommended that mother shall have parenting time week on, week off during the summers. That they both complete the high conflict solutions parenting workshop. And that the issue of parenting time and choice of school district for 2024-25 school year be referred to the front court for investigation recommendation. Catherine Scott completed a investigation. She issued a report dated August 26, 2024. She indicates that she interviewed both the children, the 10 and 7-year-olds who were old enough to be interviewed. That defendant mother failed to cooperate in any way with the front of the court during this parent time investigation. She did not respond. She was mailed a questionnaire. She was asked to make a phone interview. She did not respond at all or cooperate with the front of the court regarding this investigation. So the recommendation of Catherine Scott is that the children attend Monroe Public Schools to provide continuity, consistency for the children. That's where the children have been. Not unilaterally change them to Canton schools where they're not familiar with. And further, that mom's parenting time during the school year be alternating weekends, Friday at 6 until Sunday at 6.
Again, but Judge, if she's got them Friday at 6 till Sunday at 6, it makes no sense. Shush. It makes no sense to force her to drive back and forth, back and forth, back and forth. And there is no, and as for consistency with schools, Judge, as you know, every few years you wind up in a new school friends and school things are inconsistent. You're in with it with a new class or whatever. You know, my kids complain, oh, I'm in with my friends, I'm not in with my friends, etc. The fact is they'll make new friends. And as for the consistency from one year to the next, there's no, it really doesn't make a difference. The issue really is just during the school year, because parents pick up and move all the time. So I'm not entirely sure that extra verbiage about consistency, other than amplification, is really justified, because they are enrolled in school.
Right.
And
Mr. Rodenberg, there's been no petition filed with this court to change school districts. The mother has just unilaterally decided she's going to do this on her own. There's been no petition filed with the court to change the school district of the child to make that an issue, and school has begun this week. So the court at this time is of the opinion that children need consistency, continuity, and that they will continue in their current schools, Monroe Public Schools. And Ms. Rodriguez shall return the children to school tomorrow morning, unless you want to bring them back to dad this evening. The court will adopt Ms. Brower's recommendation, and in addition, the court's going to adopt the recommendation of Catherine Scott. Obviously, Ms. Rodriguez did not cooperate in any form or fashion to respond and provide input from the court. So parenting time for the mom will be week on, week off during the summers. During the school year, beginning this weekend, mom will have alternating weekends, Fridays at 6 till Sunday at 6. The exchange will occur at the Flat Rock Police Department.
Judge, we would ask that Mr. Rodriguez's girlfriend not be allowed to pick up the children, that Mr. Rodriguez himself have to pick up the children.
All right, Mr. Rodriguez, do you have someone else? Obviously, if there's a
no, Mr. Rodriguez himself. Only.
All good. Don't even worry about it. I'll take care of it. I'll take care of it.
Mr. Rodriguez, do you have a driver's license?
Of course I have a driver's license, yes. Yeah, I can meet there. That's fine. No big deal.
So you'll pick up and drop off the children then on, drop them off at 6 o'clock on Friday, and you pick them up on the Sunday at 6 o'clock?
Yep.
All right, so we'll put that in the
Friday, if we could do earlier,
do all the transportation.
If we could do earlier on Friday, Your Honor, because if I can't have my girlfriend meet, it's gonna have to be earlier on my time then.
Well, we're not concerned about your girlfriend. We're
on Friday, I could do Sunday all day. No big.
6 o'clock.
No, that's
Friday,
fine. But she doesn't want to meet my girlfriend, so I'm saying I can't do Friday at 6 o'clock. It has to be earlier, is what I'm saying.
Okay,
if that's what she wants, unless she wants to meet my girlfriend.
Okay,
I go into work at 3.
You can't do it, Mr. Rodriguez. Perhaps we can do it Saturday morning.
Okay, so make it 5. Can you do it at 5 o'clock, Mr. Rodriguez?
Yes, sir.
All right. So the parenting time exchange will be at 5 o'clock on Friday and 5 o'clock on Sunday.
Perfect.
So
she can bring the kids whenever
to that Flat Rock Police Department.
No problem.
So, Ms. Rodriguez, you wanted to take the children to school in the morning? You're going to take them back to you take them to school in the morning. You can take them back to Mr. Rodriguez this evening. What makes the most sense?
Well, I work. She doesn't want to meet
Rodriguez, Chelsea Rodriguez. You're going to take the children back to Mr. Rodriguez. There are children in your possession this morning. Is that correct?
Are they in mine? I'm sorry.
Yes. Where are the children this morning?
They're at school out here.
Okay.
School started.
The court has ordered that they be returned to Monroe Public Schools. Do you want to take them to school in the morning? Or do you want to take them back to Rodriguez this evening?
Okay, Your Honor, okay. Respectfully, I need to speak about this because you're putting them in a school district. You think this is consistency?
Okay. The court will order Ms. Rodriguez that you meet the Flat Rock Police Department at 6 o'clock tonight.
Judge,
5 o'clock tonight. So that's not good for Mr. Rodriguez. Exchange children at 5 o'clock tonight, and so that Mr. Rodriguez can give them to Monroe Public Schools in the morning.
No. You're not letting me speak.
Judge,
Ms. Rodriguez, hold on. Ms. Rodriguez, the court's going to order you. I'm going to mute Ms. Rodriguez for a minute. Ms. Rodriguez, if you're saying no to this court, you're not complying with this court order, I'm going to order you to appear this afternoon in this court with the children. You come down here this afternoon and we'll start contempt proceedings. If you're telling this court you're going to ignore this court's order, then you appear personally in this court this afternoon at 3 o'clock with the children. Do you understand that? Is that what you want to do? Okay, mute her. We're going to mute her. Your response. Okay, your response, Mr. Rodriguez?
Respectfully, you're not allowing me to say
Ms.
what
Rodriguez, This court is ordering that you appear with the children at 3 o'clock this afternoon, Ms. Rodriguez. You be here too, to pick up the children.
I'm
Be
not,
down
I'm
here,
not doing that. They're not.
Mr.
Judge,
Goldberg,
if
if you're not here at 3 o'clock this afternoon in this court, the court's going to issue a bench warrant for arrest. That'll conclude this hearing. You call Zoom out.
Judge, hang on, Judge. I
We
have
are
a question
done,
for
Mr.
you.
Goldberg. If she doesn't appear at 3 o'clock, the children's afternoon, the court's going to issue a bench warrant for arrest. She's ordered to appear at 3 o'clock this afternoon with the children.
No.
We're done. Zoom out.
Chelsea, you're showing up with the kids.
Like, what?
Mr. Rodriguez, be here at 3 o'clock to pick up the children. I'm sorry, Miss Brower. So we'll, guess we can modify this. Shall attend, the kids shall attend Monroe Public Schools. The mother shall appear at 3 o'clock in this court.
For the record, this matter is before the court on the plaintiff mother's objection to a referee recommended order regarding schooling of the minor child. This hearing is being conducted via Zoom. Present is Attorney Ms. Gorski representing the plaintiff mother, Kaylee Heiserman. Ms. Heiserman appears to be present with Ms. Gorski. In addition, defendant father Nicholas Suarez is also present. Good morning, everyone.
Morning, Judge.
Ms. Gorski, you're objecting to the recommended orders that the minor child who's 10 years old continue in school at Tramp Academy, and you are objecting to that since mom moved to Dundee, and it's more convenient for mom for the child to go to Dundee, it sounds like. Mr. Suarez, you're asking to retain an attorney, is that correct?
Yes, Your Honor. So I applied for the Modest Means program, but they have no panel members in Monroe County.
You applied for what?
The Modest Means program, but they don't have any panel members in Monroe County. So I just need a little more time to find adequate counsel.
Okay. What do you need, a couple weeks, 2 weeks?
Yeah, just a couple weeks, Your Honor.
Ms. Gorski, any objection to continue this for 2 weeks?
Judge, I would only ask that you keep my attorney fees in mind. I suspect that Mr. Suarez is going to show up without counsel in 2 weeks. I think this is a game. He filed a motion to change parenting time, which had been scheduled for August 1st and got adjourned to August 22nd, and then didn't show for his own motion. My client is incurring attorney fees over a very, very real issue, and I think Mr. Suarez is just taking advantage of her and me.
That's not fair to say at all. This is a very serious matter. We're talking about the education of my daughter. So for you to say that, I think isn't fair at all to the slightest bit, but I just need time to find adequate counsel.
Judge, you'll recall that my client filed this motion in June. They've actually been in front of you on it. You had suggested Ida as a halfway point. My client applied for Ida, didn't make the lottery because it's a school of choice and they didn't make the cut. Mr. Suarez, I don't believe is acting in good faith.
It's the best interest of my daughter to actually.
Mr. Suarez, don't interrupt, please.
I'm sorry.
I guess, you know, if he shows up with counsel and he shows that he's acting in good faith, of course, I have no objection. I would prefer that he have counsel. But if he's playing a game, I would just ask the court to remember that in terms of my request for fees.
Very well. Are you available on October 1st?
Gorski?
Yes, Judge. What time?
4 weeks. Yeah, that's the best we do. October 1st at 10 o'clock.
Yes.
So Mr. Suarez is giving plenty of time. Don't wait till the end of September to get that attorney board. That attorney can communicate with Ms. Gorski.
Absolutely, Your Honor.
And now, of course, today is September 4th. School has started, correct?
Yes,
There's a child at Triumph Academy right now?
she is.
Okay. All right, well, that will continue until the court can address plaintiff's objection to that. And you're saying Ida Schools is not a possibility at this point in time? It's either Dundee or Triumph, is that correct?
That's correct. That's correct, Judge.
What about Summerfield?
Summerfield is an option.
Summerfield's an option. Summerfield had released her, correct?
Yes.
But they would certainly take her back.
Summerfield's actually even further. But
I'm sorry, Mr. Suarez?
I would Summerfield's even further than Dundee.
Well, but this is about what's best for your daughter, not about your convenience.
Correct. It's not exactly. To my point, it's not to Kaylee's convenience. The best interest for Addison is to stay at the school that she was at, because she's been there for the last 6 years. Family unit, her younger brother goes to school there. She's been going to school with Nico since the last 4 years. So for her to uproot and just change her schools, especially to a school that has an F in ethnicity as a young brown girl. I think it's really important that we keep that in mind as well. Is that Dundee? There's not a lot of girls like it. Where Triumph has an A+ in ethnicity, and she's done well at Triumph. So I think it makes sense to keep her there. So it's more about Kayla's.
Right. So get that attorney on board, Mr. Suarez, and we'll enter an order today that the matter is adjourned to October 1st at 10 a.m.
Thank you, Your Honor.
All right, that will conclude this hearing. Thank you, Mr. Walker.
Thank you, Judge.
Zoom President.
Your Honor, I will have that in your queue momentarily.
Representing the defendant father, Jacob Rowley. Mr. Rowley is present. In addition, Jason Kazmarek is present, representing the plaintiff mother.
He's not here.
Oh, Jacqueline Cox. I'm sorry, Mr. Kazmarek is not present. Ms. Cox, Mr. Kazmarek does not represent you. Is that correct?
He does. He just wasn't able to be here.
Okay. Oh, I do notice he filed. Okay, I know he dropped off some responsive pleadings that he prepared on your behalf, but yes, he's not been retained.
Yeah.
So you paid him just to prepare these the objection. The court notes, Ms. Cox, that Mr. Kazmarek, you allege that there have been no charges filed and there are no charges ever pending.
Nope. No warrant.
All right. Ms. Brower, have you, oh, there, I see. So I was just trying to find, I do see the court has received a recommendation from Ms. Brower in front of the court. The recommendation is as follows. The mother shall have supervised parenting time at Downriver Family Connections and Wyandotte. Parties shall each pay for their own intakes, and the defendant will pay the session fees pending the next court hearing without prejudice. The Downriver Family Connection shall provide the court with written reports. Neither party shall discuss this case with a minor child. It's noted that CPS is still involved with this matter. The party shall appear back for this court to review the matter on September 25 at 9:15.
So when will the visit start?
As soon as possible. The party should contact, there's a phone number in this recommended order for Downriver Family Connections. I can give you the phone number over the phone. You can call them today to schedule an intake. The sooner the intakes are scheduled, the sooner these sessions can begin. Ms. Cox, do you understand the recommendation?
Yes.
Okay, we just want to err on the side of caution. And do you have any objection to the court adopting this recommendation and coming back to review this matter in 3 weeks?
I definitely object to supervised visits.
You do object?
Yeah, I don't feel like I should have to be supervised with my kid. But
Hills,
if this is what I get, if this is the only way I can see her, then like to pay to have somebody that was in your body, like you pushed out to pay to see them is crazy. But
well, no, you're not paying to see her. It's in a supervised setting where you have a.
I do have to pay. I have to pay $40 and whatever, you know. I don't know. This is all stems from me trying to discipline my kid from taking her phone away, which obviously went left. So that's the only way that I could see Aubrey until the 25th. And I guess that's my only option, right, Judge?
Well, and there's no question, teenage children can be very difficult, challenging.
Had her when I was 17.
The old days,
17,
corporal punishment is frowned upon these days, Ms. Cox. But in any event, we want to observe the interaction between you and your daughter to see, is it good? That's primarily what this is. This supervised parenting time is to do, is to have a neutral party observe that interaction. And if it's good, it's a warm environment, your daughter is engaging with you, then we get back to normal parenting.
Well, at first they wanted his sister to do it, who's definitely not on my side. So I guess I'm doing the right thing being at a center then. I don't know. All of it just makes me uneasy. So, for the record, you know.
All right. Yeah, your concerns are noted. Ms. Hills, do you have any additional information? I thought in your petition you suggest that she was arrested.
Yes, Your Honor. That's what her iChat criminal history report indicates, that she was arrested on charges of felonious assault and battery, and resisting and opposing a police officer. And I checked as late as yesterday, and the Inkster District Court, 22nd District Court, as well as the 3rd Circuit Court, are indicating that there is a warrant request pending on a charge of resisting and opposing a police officer. We did a FOIA request a couple of weeks ago to the Inkster PD. We have not gotten a response to that as of yet. We've followed up. Still no police report. I did have contact with a CPS supervisor in Wayne County finally this morning after over 2 weeks of trying to get a hold of the CPS worker, who I understand now is in foster care, and it's been reassigned to a different worker. So I'm hoping to follow up with her. That's what this adjournment will allow as well, to hopefully get our hands on that police report, talk to the worker, try to get some more facts other than, or in addition to what the 17-year-old and the 10-year-old are relaying happened. I did speak with the owner of Downriver Family Connections this morning. She indicated that they've just had a number of cases clear. They have immediate availability to be able to get these parties started with supervised parenting time. So I would definitely encourage contacting them this morning, if possible, to get that started. And it sounds like a session should be able to be scheduled right away.
All right. Ms. Cox, do you have the phone number there? Do you have a pen? I'll give you the phone number over the phone.
734-720-9234.
Yes, call them this morning and you conduct that intake over the phone. There's obviously got to be a fee for that, but you can get that to them, or I don't know if you can pay it over the phone.
Yep.
And the dad will pay for the session fees until we come back to court in 3 weeks. So try to get that scheduled so you can have some contact with your daughter. Now, Ms. Hills, if the court understands that the parties have a 10-year-old, correct, and 10-year-old allegedly observed or was present during this incident between mom and her 17-year-old?
That is correct. The 17-year-old is not a child of this case, just to be clear.
Right.
Yeah, different dads.
But the 10-year-old was a witness to her mother being arrested.
That is my understanding, yes, and to the altercation.
Well, that's obviously.
She didn't see me being arrested. She remained in the home the whole time. The police brought me outside, which then they told me that my daughter said I strangled her, rah, 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 rah. And I've gone there every week since, and there's no warrant and no pending charges against me via my lawyer has told me to do that, just because on the paper it said grounds for warrant or whatever. But
sometimes it takes time, Ms. Cox, but you acknowledge you did not go back in the house. You were led away in handcuffs by law enforcement that evening, correct?
I mean, I cannot deny that.
Okay, right. But now, if we don't want your daughter, 10-year-old, this court's only concerned about the 10-year-old, not the 17-year-old, just the 10-year-old. So in any event, the court's going to err on the side of caution. Mr. Rowley, you also call Downriver Family Connections today. Schedule that intake so we can get this moving as soon as possible. We want mom and daughter
And then
to
what,
restore
I'm
that
supposed to
relationship.
communicate with Jacob what they say, or like, I don't want to talk to that dude.
Well, I mean, I think if the Downriver Family Connections probably will facilitate the communication to schedule those sessions. So they'll part of the intake, they're gonna get your phone numbers. So both of you, please call today to get that going so we can have a number of contact sessions between mom and daughter when we come back on September 25 at 9:15.
Okay.
All right, and at that time, the court can be updated. Or anything further than this morning, Ms. Hills?
No, Your Honor, that's it. Thank you.
All right, thank you, Ms. Brawley. The court will adopt Ms. Brawley's recommendation. We'll see everyone back September 25 at 9:15 via Zoom.
Thank you.
Thank you, Your Honor.
You're welcome.
Thank you. Have a great day.
Thank you. For the record, this matter is before the court for the purpose of reviewing plaintiff mother's parenting time. This hearing is being conducted via Zoom. Present is plaintiff Jacqueline Cox. In addition, attorney Christina Hills is present, representing defendant father Jacob Rowley. Mr. Rowley is present. Good morning, everyone.
Morning, Your Honor.
The parties have conferred with Ms. Brown in front of the court this morning, who has provided the court with the following recommendation that mother's supervised visits through Downriver Family Connections shall continue. Mother shall make up supervised visit if the facility can accommodate an additional visit. Defendant will continue to pay for the sessions without prejudice and requests, and his request for reimbursement of 50% is reserved at this time. Parties shall return to this court on November 6th at 9 a.m. to review CPS reports, as well as once again review mother's parenting time. That is a recommendation. Ms. Cox, do you understand the recommendation?
I don't agree with it.
Do you understand the recommendation?
Yep, I understand it.
I'll come back to you, Ms. Hills. Is your client agree with this recommendation this morning?
He is, Your Honor.
Right. Ms. Cox, have you had any visits so far with through Downriver Family Connections? Is that commenced?
I was supposed to have 2, but he didn't show up to 1, so I've had 1.
Okay.
I don't agree with that. I feel like I should be able to see her maybe even on the weekend or something. And from what I understand from his side, he can't afford it either. Neither can I. It's a very long commute. I spoke with CPS this morning, and my worker, Miss Simmons, informed me that her recommendation is the case be closed. It's in review right now of her supervisor. I was able to gather a lot from her report. I spoke with her right before court, so I'm not concerned about that. I've never harmed Aubrey in any physical way. I just feel like I deserve more time, like to see her, to do her hair, to hang out with her. You know what I'm saying? I don't agree with it. And I don't think that it's agreeing with either my life or Jake's life to be commuting 40 minutes and paying money. So,
well, if the two of you come to an agreement, the court would certainly entertain that, but obviously you cannot agree upon that.
I haven't even spoken to him in a week or so. So, you know,
Well, that's on you, ma'am. The communication is the key when you're raising a child.
Yep, and I try to communicate with him, Judge, very often, and it takes two. You know, it's not all on me.
The court understands, but I would encourage Mr. Raleigh to respond. Ms. Hills, have you been able to confirm that CPS is closing their case and investigation?
I have not, Your Honor. I spoke with the worker yesterday, myself, trying to get an update for the court because the report was not completed and they asked for an extension on our time set in our subpoena. She indicated, and this is the only time I've had this issue come up in all the years that I've been dealing with family court and CPS cases. She indicated that even with the release that we had provided, that she was not willing to give me any information about the case. I had spoken with the supervisor just prior to the last court hearing, who had indicated that there was a safety plan in place and that the investigation was ongoing. So I have no confirmation personally that the case is being closed. We did get our hands on a copy of the police report from the Inkster Police Department. The story that was given to the police by the older child, who is not a child of this case, is consistent with what that child had told my client, and it's also consistent with what Aubriana, the child of this case, had told my client as well. So very concerning in regard to a physical altercation, which allegedly took place between Ms. Cox and the older child in the presence of the child of this case, as well as some very concerning behavior with the police allegedly resisting and opposing the police, allegedly kicking one of the officers in the groin in the process of being arrested on the domestic violence. There was a reference to a gun being in the home, although the police were not able to find that. There is still a request for a warrant on the felony resisting and opposing charge or allegation. I just checked that as of yesterday, and that's still in warrant recommendation status at this point. So we still have a lot of concerns, and I'm very interested to see what the CPS investigation report reveals about CPS's feelings about this. But my client is very concerned given what he knows so far.
So the altercation between Ms. Cox and her older daughter, as well as the subsequent arrest, that all occurred in the presence of Aubriana? Is that correct?
No, she wasn't there.
Hold on, Ms. Cox. I'll let you respond, Ms. Hills.
Per the police report and per Aubriana's statements to my client, she did witness the altercation between Ms. Cox and her older sister. I don't have any indication that she witnessed the resisting the police officer. I don't have any answer to that for the court.
But presumably, Aubriana knew that her mother was taken away, correct?
Yes, she was taken away that night by the police under threat of being tased because of her behavior.
All right. And has there been any authorization or saying of any charges, or simply pending in Wayne County?
No charges.
It indicates that she has retained counsel, that the Wayne County prosecutor assigned to the case is Mr. Luke Skywalker, and that the pending charges with a recommendation for a warrant are resisting, assaulting, and obstructing a police officer.
And not yet authorized.
Not
correct?
yet. No warrant has been authorized, correct?
All right, thank you. All right, Ms. Cox?
Yeah, this all happened August 8th. From my understanding, nothing's gonna come about from that. And if we're talking about the report, like she said, I was wrongfully arrested for something I didn't do. So yeah, that's
not an issue before this court. I just want to know, this court's concerned, was there an altercation between you and someone else in the presence of your 10-year-old daughter?
No, and I never touched my daughter to begin. And when I did get the phone from her, it was only me and my older daughter in her room. Aubriana never seen anything. I don't have a abusive past. I've never abused.
CPS will reveal that when CPS gets the final report.
For sure, Judge. I'm just stating my side. I've never abused either of my children.
No one is saying that you abused Aubriana. I'm more concerned about Aubriana.
Yeah, that's what I'm saying.
observe its
I'm talking about
altercation?
Aubriana. I'm talking about Aubriana. I feel like I should be able to see her unsupervised. I've never harmed her. I've never touched her. I'm not an abusive person. I don't have
No
a
one is
record.
alleging that you assaulted her or abused her, Ms. Cox. The
That's
allegation
what
is
I feel like Ms.
that
Hills
you,
keeps saying.
okay, I'm
I
not going to
feel
argue with you.
like
The allegation, ma'am, there's an altercation between you and someone else in the presence of Aubriana, a 12-year-old child, and that's inappropriate for a child to witness that. So if the CPS says Aubriana wasn't there, didn't see anything, then obviously we're going to reinstate parenting time when we come back on November 6th. This is 30 days off. So at this point, the court's going to adopt the recommendation. Parenting time will continue through Downriver Family Connections. Yeah, defendant will pay for the sessions, and we'll come back November 6th at 9 o'clock. Hopefully we'll have those CPS reports that will confirm Aubriana was downstairs. She was down the street at a neighbor's house and was not present, didn't see anything. We get back to regular parenting time. Is Aubriana currently in counseling, Ms. Hills?
I do not believe so, Jacob.
She should be.
No.
Yeah, and I agree.
Agree
Court's
on
going to
that.
add this recommendation. Obviously, she's right now being, disrupted her parenting time with mom. So the court's going to order that to dad that you and enroll her in counseling.
Okay.
With that added,
That's fine
so find out what your insurance covers and make those phone calls to different agencies today, please. Get that started.
Yes, sir.
So we can add that to the recommendation, please, Ms. Brower. With
Yes, Your
that,
Honor.
that will conclude this hearing. We're going to zoom out, have the rest of the day.
Great. Thank you, Your Honor. You too.
For the record, this matter is before the court. Any defendant's objections to a referee recommended order denying his motion to modify parenting time. This hearing is being conducted via Zoom. The parties have conferred with Mr. Pratt for the front of the court. I'm sorry, strike that. It appears that both parties are present. The plaintiff mother, Megan Brooks, and represented by attorney Christina Hills. And the defendant, Father Anthony Balestri, is also present. Good morning, everyone.
Good morning.
Morning.
Mr. Pratt for the front of the court this morning is recommending that referee recommended order be adopted. Namely that there's sufficiently not sufficient circumstances in which to modify parenting time, Mr. Balestri. Mr. Balestri, do you understand the recommendation this morning?
Yes, sir.
Any objection to the court adopting this recommendation?
Yes.
Okay. Well, we'll hear from Ms. Hills, and I'll come back to you. Ms. Hills, what's your client's position on this recommendation?
Your Honor, my client's position is that the recommendation should be adopted and become an order of the court. Dad has parenting time every Wednesday overnight, plus alternating weekends from Friday through Monday. That is substantial parenting time. He also has the friend of the court holiday schedule. Our position is that he has not alleged a sufficient change of circumstances under Shade versus Wright to modify parenting time. Simply objecting and saying I deserve 50-50 parenting time is not a sufficient basis for an objection to the referee recommendation. Dad works midnights. He has acknowledged that. The overnight that he has in the middle of the week, his girlfriend is with the minor child. The only additional parenting time that he could have, since the parties already alternate weekends, would be during the week when he's working midnights and the child would again be left in the care of the third party, the girlfriend. My client is available to the child on an overnight basis. So that's another reason why parenting time should not be modified at this point. This child is doing very well in school. She got straight A's. Both parties acknowledge that. She's in extracurricular activities. She's thriving under the current schedule, and there's really no need to rock the boat from that standpoint either. So we are asking that the court adopt the recommendation and maintain the current parenting time schedule.
Thank you, Ms. Hills. That's wonderful. The court is pleased here that Madeline is doing so well. Obviously, the two of you as parents are doing something right. She's obviously thriving in school and engaged extracurriculars, good grades. You got to be extremely proud of that. And Mr. Balestri, I just warn you, you should not discuss parenting time with your daughter. That is a major no-no. I mean, this is between parents and the court. And if the two of you as parents cannot agree, then the court will decide. But these things are not things you should discuss with your daughter. That just creates anxiety on the part of your daughter. That does not reflect well on you as a parent. You should not be discussing parenting time with your daughter and saying, obviously you can say things like, obviously Dad, I enjoyed every minute we can spend time together, but you shouldn't be putting it on her in terms of going out to her mother to get more parenting time. So at this point in time, the court believes that the current schedule is appropriate. Now, what about, you can talk about summer parenting time. The court sees no reason why you couldn't do week on, week off during the summertime. Obviously, there's got to be more of a stricter schedule during the school year.
I also
Premature to discuss next summer, Mr. Blesser, with court would suggest maybe at in the spring to file a petition to modify summer parenting time. Or maybe you and Ms. Brooks can agree upon it in the interim. Go ahead, Mr. Blestry.
I no longer work Mondays, so I mean Monday night would be good too, because I work for Ford and they changed my work schedule. I no longer work Monday through Friday. I work Tuesday to Friday.
Your Honor, if the court were to consider extending parenting time to include Monday overnight, that would mean Monday overnight with dad, Tuesday overnight with mom, Wednesday overnight with dad. This child would just be ping-ponged back and forth. We certainly will talk about the issue of summer parenting time if that's raised down the road.
Mr. Blestry, it's a legitimate concern. We don't want Madeline to be bouncing back and forth, back and forth. It's a lot, especially during the school year. The child needs consistency.
I understand that, but she doesn't even have consistency when she's at her mom's, because when her mom works days, okay, and when she leaves to go to work, she'll either leave Madeline at home with her boyfriend or she'll take her to her grandma's house. So she's already bouncing back and forth when she stays at her mom. There's no consistency of where she's staying when she goes to work at her mom's, because I get text messages every day that's different on where to pick Madeline up from. So there is no consistency anyway. She's bouncing back and forth between her own house with her boyfriend, or she's taking her to her grandma's house. And I have to get a text message every day of where to pick her up. It's not consistent. And I have text messages in my phone to show those.
Ms. Hills?
Your Honor,
Does Ms. Brooks have a response?
Childcare while she's working, and she does what she can with regard to the childcare. Ms. Brooks, did you have something you wanted to add?
So yes, when it comes to bouncing back and forth, as he's stating, she does stay at home sometimes, and this is only during the summer because she goes to school during the school year. Obviously, she's not going into childcare. But during the summer, she will either stay at home if my fiance is off work, or she will go to my mother's house where my sister lives, and she is with my sister and her cousins that are her age as well, throughout the day while I'm at work. It's just a child care or like a babysitter in the interim. It's not an overnight thing.
Well, Mr. Blestry, the court understands your concerns and your position, but the court, however, at this time will adopt the referee recommended order that that parenting time not be modified at this time. But again, there's no reason why we can't talk about summer parenting time. So the court suggests in the spring, if you and Ms. Brooks don't have some agreement about, perhaps no reason why we couldn't do a week on, week off during the summer. It's much more flexibility during the summer months when school's out, looking at your work schedule and her work schedule, and file that motion in the spring. But at this point in time, the court will adopt the recommendation.
Your Honor, is the court adopting the recommendation in its totality? There was a recommendation for counseling for the minor child to begin with a counselor named Brenda Paulicki, who had been agreed upon, I thought, at the referee hearing, but then subsequently Mr. Blestry objected to counseling starting with that counselor. So we would ask the court to adopt the rec in its entirety.
I don't agree with that.
Mr. Pratt this morning, Mr. Blestry, why are you opposed to Dr. Paulicki counseling your daughter?
Because her and Ms. Brooks are good friends and stuff, and I don't want that to alter the decision or how my daughter talks and acts. And last time we did some his name was Glenn, Mr. Glenn, I remember. It was by the court, and neither me or Ms. Brooks knew who he was. And Madeline did very well. And there was no outer influence. So I would feel more comfortable if it was with a counselor that me nor her knew, because her and that counselor that they recommended it, they're friends and they talk and all this other stuff. So I just would feel like it would be a more genuine outcome if it was a counselor that me nor her knew. And yeah, I just feel like it would be a more genuine outcome and there would be no outer influence.
All right, Dr. Paulicki is with New Beginnings Mercy House. Ms. Hills, does your client have a relationship with personal relationship with Dr. Paulicki?
I understood that she had counseled the child in the past, if I'm My client's saying no, so I'll let her answer.
She never counseled Madeline. Brenda and I served on the board of New Beginnings Mercy House together.
So they had a relationship. That's why I don't want no outside influence.
Well, serving on a board together certainly doesn't equate to a personal relationship.
Well, it can be influenced to her because they have seen and been around each other before. So I would just feel more comfortable with a counselor that me nor her knew, and there would be no excuse for anything.
Well, if you want to find a counselor that will take the insurance that that your daughter's covered by.
She's under my insurance.
All right, so all right, no, it's a valid point. Obviously, if they serve on the board together, they have a relationship, and she may, Dr. Walicki may, she's a professional, may share more information with mom than she does with dad. So the court will order counseling, but court will order that counseling to be conducted by a mutually agreeable counselor.
Okay.
Do you think you can discuss and agree upon one?
Yes.
Again, if it has to be an agency other than New Beginnings Mercy House. Friend of the court, I'm sure, has a list of counselors. Ms. Sills, I'm sure, can also provide some recommendations. So the court will adopt the recommendation of the referee, with the exception of and thank you for pointing that out, Ms. Sills. I did not note that in the recommended order, that counseling to be continued with Dr. Walicki. So the court will adopt a modified counseling for the child shall be performed by a mutually agreeable counselor.
Thank you, Judge.
So with that, Mr. Bradley, you just add that to the recommendation, just add that one provision. That's the one modification of the order. Otherwise, the order is adopted.
Yes,
Well,
sir.
continue to work together, Mrs. Brooks and Mr. Blastry, for the welfare of your daughter. She's doing well, and you want to continue that. And be careful. Don't involve your daughter in some of these adult decisions, Mr. Blastry, please.
Okay, I understand, but when my daughter comes in my room and asks me to have a talk with me, I'm not, Judge, I'm not going out of my way to talk bad about her mom or say, oh, I deserve to take you. I'm not trying to take her away from her mother, and she understands that. She gets upset because there's been occasions where she said she was over here for 4th of July, and she was having a really good time with me. I was off for work. I had a week off of work, and she was having a really good time with me. And she said, Dad, I really don't want to go home. I want to stay here the night with you again. I said, okay, well, that's not for me to decide. I can't just keep you because your mom's supposed to take you back. You have to call her and ask her. And when she called and asked if she can stay with me another night, Megan said absolutely not, and told her no. And when she got off the phone, she locked herself in her room and cried until her mom came and picked her up. So, I mean, there's got to be some kind of leeway where if she would like to stay, she can't just tell her no every time. Just like if she wanted to stay longer with Megan, I would not say no. There's not been a time where she asked if she can stay longer with her that I say no.
Can I add to that?
There's got to be a mutual thing for that.
Hold on. Your Honor, Mr. Blestry should have called my client instead of putting the child squarely in the middle of the situation and thereby putting pressure and giving the child anxiety regarding that issue. At some point, hopefully the parties can reach a point where they can have those sorts of conversations and vary from the court order. I don't think we're quite there yet, but certainly I will encourage my client to work on that. But the child should not be made a messenger.
She's not a messenger. She asked to call her mom if she can stay the night. How am I? Why does that? I mean, why do I have to be involved in that?
Mr. Blastry, because she's a child, she's a minor. So yes, you're the one that should just say, well, check with your mom. That's what she responds, and you call Miss Brooks to discuss that, rather than put that child in the middle to work through that. It creates anxiety for the child. So
Yes,
with that observation, that will conclude this hearing, and we will please work together, get agree upon a counselor as soon as possible, so that can continue for Madeline.
Yes, sir.
All right, that will conclude this hearing. You can both zoom out.
Thank you, Your Honor.
Thank you, Your Honor.
Yes.
All right, good morning. For the record, Mr. Wardell Smith is appearing via Zoom this morning. Also present is his court-appointed lawyer, Timothy Leiter, as well as Monroe County Front of the Court Attorney Rebecca Hicks, who's appearing via Zoom this morning. The court has been informed, Mr. Smith, you posted a $500 bond, and that's why you're out of jail. So that's fine that you appeared remotely this morning. Of course, that bond will apply toward your rearages.
Yes. That's what the bonds people told my mother-in-law. Yes.
So again, it's not going to attorney fees or costs. It's going to benefit you 100%.
Thank you.
So that'll bring your arrearages down to a nominal amount, but you've got to make regular, consistent payments. And Ms. Hicks, in light of that, Mr. Smith, the posting bond, are you still asking for a finding of contempt this morning?
I am, Your Honor, but
Huh?
obviously I'm not asking for any immediate jail. I'm asking that he just get credit for the 2 days that he served in jail, which would just leave 43 days hanging over his head in case he falls back out of compliance.
All right, Mr. Smith, do you understand that recommendation? Basically, the court would continue with contempt proceedings, but the court would hand you the key to the jail. In other words, you would not serve another day unless you fail to comply with orders of this court. Do you understand that?
Yes.
And so there would be no action taken today other than a review date before Ms. 6 and perhaps 6 weeks down the road. Mr. Smith, are you satisfied you received the right to legal counsel by conferring with Attorney Timothy Leiter?
Yes. Yeah.
Okay. Leiter?
I can't. I don't know if they can.
Your Honor, we can't hear what Mr. Leiter is saying.
No. Oh, I'm sorry. Yeah, the microphone's turned around. We have a new sound system and it's not that great. So yeah, why don't you start again, Mr. Leiter? I'm sorry.
Yeah. Your Honor, I still can't hear him.
Okay, let me try it again. I'll get it right. Your Honor, if there was any confusion here, I will own up to that because I tried to get a hold of Mr. Smith yesterday, set up a jail appointment, but didn't realize he bonded out. I know that he paid the $500. I was confused as to where the payment went and everything. Now I do understand, and Mr. Smith understands that the $500 will be due to arrearages. Ms. Hicks is asking for a finding of contempt, but she won't be asking for any additional time. So, Mr. Smith, if that's satisfactory to you and you wish to admit to the finding of contempt, please indicate so. If not, you'll have a hearing.
Huh?
I thought I made it.
And the recommendation, Mr. Smith, is that if you admit to contempt, the court would reserve any sentence. The court would order 45 days, give you credit for 2 days to serve, and the 43 days would be hanging over your head. You understand that?
Yes.
Okay. Is it true that you wish to admit to contempt pursuant to that favorable recommendation?
What other options do I have?
Well, if you don't want to acknowledge that you failed to pay support, you've not made payments since May of 2024, then we can have some testimony from Ms. Hicks this morning.
Oh, since May of 2024.
Correct. Since March of 2024.
April. Oh yeah, I was paid up to April. Yeah, I missed a couple months. Yeah, I acknowledge that I missed a couple. Yes.
Okay. Are you willing to admit to contempt for failure to comply with the orders of this court or not?
Yes.
All right.
I guess.
Mr. Smith,
Yep.
raise your right hand to be sworn. Do you solemnly swear or affirm that the testimony you're about to give this matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yes. You want me to raise my right hand? Can you see me?
I'm sorry?
Can you? I can't see anyone. I can't see any. Can you see me?
No, because you're on the phone. That's fine. We can hear you.
Oh, okay. Okay.
Everything's recorded. Please state your name for the record.
Wardell Smith.
Okay, your current mailing address, Mr. Smith? Mr. Smith, did you admit and acknowledge that you're obligated to pay support for the maintenance of children born to you and Rashay Evans?
Yes, I didn't pay the make a payment since March.
Smith, you admit and acknowledge that when you were arrested on this bench warrant for failing to appear for review hearing that you had arrearages in excess of $600.
Yes.
You admit and acknowledge you've not made any payments of child support since March of 2024.
Yes.
Did you have any income after March of 2024?
No.
How'd you support yourself in the last 3 months?
Well, little odd jobs. Like far as like, I just doing little odd jobs, just doing just little odd stuff to make them
Okay, you
make
said you
ends
had
meet.
no
That's
income.
why What, like far as what? I didn't have enough to make the payment because it's been
Mr.
tight.
Smith,
I didn't have
Mr.
enough.
Smith, let me start over again. Did you have any income? Did you receive even $10 in income since March of 2024 from any
Oh,
source?
yes.
Okay, and you acknowledge you didn't pay any of that toward your child support. Is that correct?
Yes.
All right. The court finds, based upon Mr. Smith's testimony, as well as the records on file with this court, that Mr. Smith had arrearages in excess of $600 when he was arrested on his bench warrant. He failed to appear for review hearing. He's not made payments since March 2024. Notwithstanding the fact he had some income since then, he's not exercised due diligence by having contact with the front of the court. Accordingly, the court finds Mr. Smith to be in contempt of court. Mr. Smith, the key is if you break your arm or break your leg, be in contact with the front of the court. You could avoid finding yourself in these situations if you are proactive. Don't sit in your hands. If you are injured, file a motion to reduce your support. Come in and talk with the front of the court. Don't just ignore these matters. That's what happens when you ignore them. Understood?
Yes. And
Right.
I would like to also state something for the record. I would like to also get established paternity because since that's one of the reasons why I haven't seen my daughter in almost 3 years. He told me that the child isn't mine, so I want to establish paternity for the court to know.
Talk to an attorney, Mr. Smith. Again, if the child's more than 3 years old, you're going to have a tough battle. You need to do that timely. If you're going to challenge paternity.
Yeah, because the child doesn't have my last name. I didn't sign no birth certificates or nothing like that. It was just that. And then if I think that the child is mine and now the mother's saying that the child's not mine, I do want to establish paternity for the court for my.
Need to
for
file an
myself and
action.
my wife.
Contact an attorney, Mr. Smith, and file an action. It's not before the court this morning. The only issue this morning is child support arrearages. So if you want to challenge paternity, then you need to talk to an attorney. You could be too late. You can't wait till this child is so old. In any event, that's another matter for another day. You need to talk to an attorney about that. So the court's inclined to follow the sentencing recommendation. Mr. Lader, anything further this morning?
Nothing further, Your Honor. We do thank the court as well as been stated.
Thank you, Mr. Lader. Mr. Smith, is there anything else you want to say before the court imposes a suspended sentence?
No.
All right, the court having found Mr. Smith being contempt of court, the court will order that he serve 45 days in Monroe County Jail as follows. 2 days immediately is given credit for the 2 days he has served. The balance of 43 days is suspended and reserved. So Mr. Smith, you got 43 days in your head, but you hold the key to that jail. You can avoid any additional time by being proactive, keeping contact with the front of the court, appearing for review dates. Okay?
Yeah, I filed my file a petition.
Right now, your child support is pretty low, $97 a month. If you say if you break your leg, can't afford it, you need to file a motion to reduce your support. Be proactive. And finally, we're going to give you a date to appear back for a review date. Ms. Six, what date do you suggest for Mr. Smith to appear back for you?
November 19th at 1 p.m.
Okay, Mr. Smith, you'll be mailed a notice. You are to appear before Ms. Six for review November 19th at 1 p.m. November 19th at 1 p.m. A copy of the notice will be mailed to you. Just make sure you appear on that date. You can appear by Zoom or by phone if you're working. And what she's going to know is that they made payments from and after today. You need to make some payments between now and November 19th to avoid any additional jail, okay?
Okay.
Do you have any questions, sir?
No.
Okay, you're all set, Mr. Smith. Get back to work. And make sure you mark that day November 19th on your calendar at 1 p.m. Thank you, Mr. Leiter.
Okay.
Your Honor, thank you.
The defense motion for to show cause. Defendant alleging violation of parenting time orders on the part of the plaintiff. This hearing is being conducted via Zoom. Present is the defendant moving party, Barry Ellison. In addition, Christina Hills is also present representing the plaintiff. Danielle Williams and Ms. Williams is present. Good afternoon, everyone.
Good afternoon.
The parties have conferred with the front of the court this afternoon.
Yes, Your Honor.
Yes.
Front of the court noting that defense requesting a fine of contempt regarding denial of parenting time. It also recommended the show cause be adjourned to October 1st, 2024, 10:30 to correspond with a motion to change custody. I believe the motion was filed by plaintiff. Is that correct, Ms. Hills?
Yes, Your Honor.
Filed a show cause against Mr. Ellison alleging that he is violating parenting time orders as well, correct?
That is correct, yes.
Okay, it makes sense to have them both together. Then the court, if the court determines there's a basis, the court can hold both parties in contempt, and maybe appropriate that they both go to jail together. So Mr. Ellison and Ms. Williams may want to have someone watch the children the evening of October 1st if you're not available to parent.
Your Honor, I was checking this.
So the court will adjourn this matter to October 1st at 10:30. You have a question, Mr. Ellison?
Yeah, I was just inquiring. She said she wanted to set some evidentiary hearing up. I was seeing if that was in that as well.
We will address that on October 1st at 10:30.
So it's evidentiary hearing then, Your Honor?
No, it's a motion hearing. Both of you both have competing motions. You're both throwing rocks at each other, complaining that you're calling each other names and you're violating parenting time orders. So if the court finds that, the court will hold both of you in contempt, and the court very, very likely may impose jail sentences for both of you. Maybe that's why you need to spend the time in jail together. I mean, the two of you need to parent, and the court's getting quite honestly tired of both of you coming back to court every other month.
I'm not the one bringing her, Your Honor. My court is just my 2 days is she violate that. I don't throw no stones. I got my evidence, so I'm ready for October. I'm ready.
Okay, maybe I'll bring your attorney with you, Mr. Ellison.
I definitely will, sir. Police reports and all.
Okay. All right. Anything further, Ms. Hills?
Not at this time, Your Honor. Thank you.
All right. It's better. We'll see on the October 1st, 10:30.
Thank you.
Okay, everyone zoom out. Have the rest of the day.
You too, Judge.
Thank you, Your Honor. Have a great day.
Welcome.
You're welcome.
Am I out of court now?
Yes, you can zoom out.
Did you need any, was that rec okay, Your Honor? Do you need any corrections to it?
No, actually, well, that's exactly what I was going to do. I knew
Okay.
I signed order to show cause earlier this week, and I thought it was October 1st. I was going to ask Ms. Sills, and I was going to combine these two. I might hold them both contempt and give them both jail time. I'm so tired of those two.
It would work for the front of the court, Your Honor. Yeah.
So,
All right. I'll go work on your 130. I'll be right back. I think that they pretty much are done. Ms. Gorcey's asking for attorney fees and a lump sum payment that Mr. Bartlett's client said he can't pay. The quadros have been entered. Mr. Bartlett.
I've not seen it yet. I've not signed the court file yet, so maybe I'm not sure
No,
where it's at. That's
they're not based, but you haven't signed them yet, Your Honor.
oh, okay.
Yeah, no, but they're there.
That's
They're just
one question I had.
Yeah.
Status of the quadro,
Yeah.
and then Mr. Licata was to provide. I had to July propose a plan for you to address these spousal support arrearages. So I'm expecting that from him.
Yeah, he does not. His basic is I don't have a plan, so I'll just bring them out and I can type up the record as you're talking.
We start contempt proceedings then.
I guess so, because he says I don't have a plan. I'm in bankruptcy. I can't afford it. They're going to talk about the front of the court IWN. I do have an active IWN. But it's only going to let me collect $326 a month because that's guidelines on the child support. We've received 2 payments, and I can give you that total.
He's got arrearages about 15,000.
16,503, Your Honor. I've received for August. We received $1,309. Okay.
Okay.